Hi friends, and welcome to the 7th lecture of Jurisprudence. This is Lokesh Pathak with you, and this lecture is going to be very small because today we'll just cover the Indian Constitution and Grund norms. What is Grund norms concept? We have already seen in previous lectures, and now we'll see what is the analogy between the Grund norms with the concept of sovereign given by Austin and how it's relevant to the Indian Constitution. So we have seen that Grund norm, they were quite analogous to Austin's concept of sovereign because it talks about the basic norm which governs the validity of the other norms down it, and the same concept can be inherited in view of Indian Constitution because we have seen that Indian Constitution, all the legislation and statutes in the context of India, they derive their validity from Indian Constitution. So it is true to say that Indian Constitution works as a Grund norm for us in Indian legislation. But the interpretation is not so easy because if we try to compare Indian Constitution and Grund norms, and since Grund norm is analogous to Austin's approach, so we will see that there exists some contradiction in the past Indian law and order because there had been a contradiction in ancient Indian law as compared to the implementation of Grund norms or Austin's concept of sovereign. So, what are those contradictions? First of all, before going through, we will just recap on the analytical positive concept given by Austin and Immanuel Kant and H.L.A. Hart, because it has the assumptions that sovereign or Grund norm, they bears an analogy. They are almost same, and they are considered as a law creating authority. While the analytical positivism, it says that law as it is has to be followed. Hence, it excludes the concept of morality, which we have seen in the previous classes. And also, in an analytical school, the concept of sanction, it is given a huge weightage because it's a coercive force which is behind every enforcement of law. So these concepts, when we see, they contradict to some extent with our ancient Indian law. Because as per Indian ancient law, the which is called dharma, the law is given the highest place, and but at the same time subjects and rulers are equally bound to follow the law. If we see what dharma is mentioned in our Vedas, Smritis and Shrutis, the dharma is divided into three parts, that is achar, vyavahar and prayashchita. I'm repeating, dharma says as per ancient Indian law, which the source of which is Vedas and Smritis, it says that dharma is divided into three parts, which is achara, vyavahara and prayashchita. Achara is rules of daily routine which need to be followed by all the humans, while Vyavhara is only for the rules of decree or command of king. So here you can see the king is equally bound with the rules, and Prashchita is the theory of penance. So these are the things where we can find there is a contradiction with Austin's approach because here the Vyavhara is determining the rules for even the decree or the command of the king to follow. And also, if we see in the ancient Hindu law, there are coexisting concepts of law, morality, and religion. While Austinian school or analytical school, it does not provide a proper weightage to morality, and it says law as it is. So this is another contradiction which is seen in ancient Indian law and the Grund norms. So now what happened if we go, because when we see these contradictions, now let's analyze the Indian Constitution and its relevance to the Grund norms or the concept of sovereign given by Austin. So as we see for the Indian Constitution, it can be termed as a Grund norm in Kelsenite sense because all statutes and legislation enactments, they derive their validity from Constitution of India. And as we seen in a famous case of Keshwanand Bharti versus Union of India, which is AIR 1973, in that case we have seen that it is held that the constitution is presupposed to be valid. So the validity of the constitution is already determined in the jurisdiction of India, and all other statutes derive their validity from the constitution, and hence it is considered in Kelsenite sense as a Grund norm and with Austinian sense as a sovereign. So another resemblance with Austinian pattern, we have seen that extensive powers are given to executives in certain acts in Indian jurisdiction like Tada and Pota. And in the implementation of these acts and the enforcement of these acts, the extensive powers are granted to the executives, and hence it again supports Austinian's pattern related to sanction and enforcement of the law. There has been other cases in the jurisdiction which elaborate the sensibility of the Indian Constitution. One of them is habeas corpus case, which is between ADM Jabalpur versus S. Shukla. It is a AIR 1976 case where it was said that writ is not maintainable as long as Article 21 right is suspended during the emergency. So that case is a milestone case. We'll discuss about it in the classes of constitution, but just to mention here that such contradiction are faced with related to enforcement of law. Although this case later during as per the 44th amendment of the constitution, this was changed and article 21 was taken out of purview of the emergency provision, and it is said that this will remain enforced irrespective of the emergency, and this was later enforced in the case of Maneka Gandhi versus Union of India of AIR 1978. So this is all we discuss about the constitution, its resemblance to the Grund norms, Kelsenite theory, as well as Austin's sovereign concept, and the extensive power it gives to the executive in line with Australian pattern. Some case law we have seen, and at the same time, before that, it is worth to mention that this is not blindly followed. There are certain contradictions with our ancient Indian law and the Kelsenite interpretation based on Grund norms. So that contradiction we have seen. So if this question comes, this may come as a separate question in jurisprudence, and that is why I try to catch this question as a separate topic. So in the next and the last class of jurisprudence for the year 1 students, we will discuss about the American modern realism and realist theory of law, and also we'll talk about the economic approach of law. Thanks for attending. Stay tuned. Bye.